You've reached the stars. Now let's see you conquer galaxies.
Planning tools and key considerations for families with unique circumstances. Also joining us this morning is Mr. Moshood Shehu. Moshood Shehu is the principal counsel at Moshood Shehu and Associates Legal Practitioners. He's a man with vast experience. He's the publisher of the Gravitas Review of Business and Property Law, which is Nigeria's most influential and best-selling law journal. Mr. Shehu has extensive experience in commercial and transactional law. And this morning again, he will be speaking to us on the legal landmines to avoid in planning your estate, with a critical focus on family businesses and entrepreneurs. Esteemed guests, I like to urge each and every one of us to be steadfast. Let's be attentive, because I can assure you that the next hour promises to be worthwhile and life-changing. We urge you to drop your questions because we anticipate there will be a lot of questions. Make use of the Q&A tab below your screen. All questions must be dropped there, and we assure you, as much as possible, would ensure they are all answered. The ship is set to sail, and I'd like you to join me to welcome our first guest speaker, Dami Lola Assange, as she educates us on the why, the what, and the how of estate planning. Dear Dami, the floor is yours.
Thank you, Omoefe, and let me welcome everyone once again to this webinar. I would like to just quickly share my screen, but before I do that, so what I'm basically going to do is to lay the foundation of what we're talking about for the next hour and 15 minutes thereabouts. Estate planning, what exactly do you need to know? What are the considerations and all of that? So I'm just going to lay the foundation and allow Ebele and Barrister Moshood, to do justice to other details. And then, of course, at the question and answer session, I will come in as well, and then we will together try to answer those tough questions. I'm launching a poll now. So you just need to click which answer is relevant to you. It's of course, we wouldn't know who is picking what. This is just to give an idea of what is going on at your end. So I launched the poll. Just tick your answer and then we'll see the outcome. So I've launched the poll. Okay. Yes, participants are responding. Interesting. Okay. About 60% have responded so far. Yes, people are responding to the poll, so I believe they can hear us. Interesting.
Okay, great.
So we have, okay, one more minute. Oh, no, not up to a minute. We have to end this now. Have limited time. Great. I think I will end the poll now. 73% of participants. Okay, participants are still voting. Sorry, they are still taking their option. So another 5 seconds. Okay, so I have to end the poll now. It's 1 minute and 30 seconds now. So we have 78%, which is a very fair percentage of attendees. Share results. So can we all see the results? Do you have a will, trust, or any estate planning instrument in place? So 8% of attendees here said yes, they do. 84% said they don't. 8% said somewhat. Trust me, the somewhat is usually very close to the I don't. And then I'm glad that nobody here is saying that they do not need it. So it means that we're on the right path. We have chosen the right topic for you. Okay, so I'm going to share my slides now. And I mean, this just goes to tell us that indeed, we have a lot to talk about. We have a lot to bring to the table when we're discussing estate planning. Share. So can we see my screen?
Yes, Dami. Yes, Dami, we can.
Okay, great. Yes, so just to run through this, why, what, and how of estate planning. We decided to focus on wills, trusts, estate planning generally speaking, and understandably so, even from the poll that we just conducted now, we can see that this is a relevant topic that we all need to confront and address once and for all, because it's important that we preserve our legacy. Now, there's so many myths out there regarding our estate plan, regarding planning for your estate. The very popular one is that people believe that the moment they begin to discuss their estate plan, then they're invoking death. I don't know how many of us here think so too. Some people believe that it's just the wealthy that need to set up a trust, while others think that they are too young to set up a trust. Some people feel that setting up, estate planning generally speaking, not even just setting up a trust, estate planning is reserved for a certain number of people, not for all. They believe that you need to be extremely wealthy. Some people believe that, oh no, my spouse and my children are cool. If anything happens to me, I don't have anything to worry about. They can sort themselves out. There will be no rancor or fight. We can tell from the different happenings around that that is not so. We've seen siblings squabble over inheritance. We've seen families in huge disarray. We've seen, and these are not even, these are families with similarly simple family trees. And we've seen them squabble, fight. We've seen law cases. We've seen situations where the head of the family dies, and months and months and months after, the burial is not done simply because there's a lot of disagreement. So what is an estate? Is in totality your property, whatever you own as an individual, your real and personal properties. And so planning your estate simply means putting together all of these properties, all of these things that you own in your name, in a situation, in an orderly manner, such that there's guidance on how you want to ensure that it is transferred at the end of the day. So the wealth planning cycle is about wealth growth, wealth preservation, and then ultimately wealth transfer. So if you have taken time to grow your wealth, you've done a lot of investments and all of that, and you've put you've put measures in place to guard against risk, that's preservation. You need to also put measures in place to transfer, such that everything you've worked for does not just go to waste. How can you plan your estate? There are several tools to it. You can have a will, it can be simple, it can be a comprehensive one. Trusts, I believe we'll be talking a lot about trusts this morning. You can set up a special purpose vehicle, and that's holding your assets in a company created specially just to provide that for you. It could be by deed of gift, power of attorney, joint property, ownership with right of survivorship. The options are quite many, and I believe between Ebele and Moshood, we'll be doing justice to all of these options this morning. There's a starking difference between a will and a trust. I will not go into this. I need to save my time. I am very sure that Ebele would speak more to this in her slides. But what do I think you need to know as you listen this morning, as you participate in this webinar? I think you need to bear in mind that we're talking about your legacy. We're talking about you preserving your legacy. We're talking about the different things that you have labored for over the years, ensuring that in the case of a sudden incapacitation, death, or whatever it is, that you are well prepared, you know, and your estate is not left, you know, just in the hands of anybody. You also need to bear in mind that whatever tool you explore, you know, in my previous slide, I talked about some of the tools, wills, trusts, and all of that. But you need to know that whatever tool you explore will largely depend on the size of your assets, would also depend on your family circumstances, and of course, your unique priorities. So what are the things that are important to you? If something is quite important to you, you would prioritize it, and then that would help to determine what tool that you want to explore. You also need to bear in mind that it's important to work with professionals while making this happen. I would say that in estate planning, doing it yourself, DIY, can be quite limiting. So don't think that you can do it by yourself. Even if you think you can do it by yourself, why not run your ideas by your professional partners? Meristem is a good partner you can work with, you know, to ensure that you're on the right track and all the important things are taken care of. And of course, bear in mind that there are measures you can put in place to further protect your trust. So you need to explore all of those measures, and at the point of discussing with your professional partners, would address some of those things. So what am I saying? You need to evaluate what is it that you want to achieve. Have an inventory of your estate. Do you have an inventory of your estate? Okay, I leave that question for you to answer. Then choose your tool. Like I said earlier, your tool largely depends on what makes up your estate and your unique family situation and your priorities. You then have to implement your plan. So we have people who have been trying to write a will for several months, running into years. You just need to get it done. You just need to do it and move past it. There's absolutely nothing linking preparing your estate with you dying early. It has absolutely nothing to do with it. So don't think at any point in time that preparing your estate is a bad omen and is an indication that you're going to die early. No, it's not. So just to introduce formally who we are, Meristem Trustees is a subsidiary of Meristem Securities Limited. We are registered and licensed by the Securities and Exchange Commission as a capital market operator. And of course, we are active as a member of the Association of Corporate Trustees of Nigeria. Our role as your trustees is to act as your representative. So it's a fiduciary role that we play. It's a trust role. We partner with you to ensure that whatever it is that you wish regarding your estate is well documented and executed. You also have the benefits of the fact that we are a going concern. I know that a number of people have considered and have actually used individual trustees, you know, but then the issue with an individual trustee is anything can happen to that individual, you know, that they may not be available to provide the supervision and everything that you want for your estate. But with a corporate trust company, that is not the case. Our service offerings range from corporate trust services to estate planning and private trust, education and endowment funds, you know, and the list goes on. And of course, whatever it is, we are ready to provide that customized service to suit your needs. We will be sharing our contact details at the end of the meeting. Allow me to stop now. I'm sure I have used up my time. Thank you very much. I'll be sitting quietly by, waiting for the question and answer session to take your questions. Thank you.
Thank you, Dami. Thank you, Dami Lola. That was great. You didn't use up all of the time. At least you saved us about 2 seconds.
I'm glad.
Thank you. For those of us joining us, that was Dami Lola Assange. She's the Managing Director of Meristem Trustees Limited. We'd like to say welcome once again to the second edition of our Wealth Preservation Series. And this morning, we're talking about preserving your legacy, the little things that matters. Particularly, I like the poll taken by Dami Lola, and that gets to emphasize the point why we're having this session today. A lot of us have not tried to plan for what will happen after our lives here on earth. What would be the lots of our beneficiaries? You know, a couple of months ago, I was reading on the news, the late High Chief Lulu Briggs. What a billionaire with estates worth billions of naira. In fact, Forbes' presentation of top 10 families in Nigeria named him as one of the richest families in the country. But today, what is happening to his estate? Is it that he never planned to ensure that all of those assets were properly dissipated to the beneficiaries? Or was it that he planned and he never planned properly? These are a lot of questions that are being asked all over the place, you know. And this morning, the essence is for us to address these things. You might look at yourself and say, okay, I don't have the billions Lulu Briggs have, but definitely there's something you have. And you have your children, you have your wife. What plans are you putting in place for them? Next for our panelists this morning is Ebele Chukwueneda, and this morning she'll be taking us on estate planning tools and key considerations for families with unique circumstances. Dear Ebele, you have the floor. Thank you.
Thank you. Thank you so much, Omoife Tiger. Thank you, Dami Lola. You have really made my work very easy this morning already. My name is Ebele Chukwueneda. I'm a partner in Nuka Attorneys and Solicitors. And like them, and like Omoife has already told us, estate planning tools and key consideration for families with unique circumstance is what I will be talking to you about. And I welcome you once again to this very important discourse for all of us. And we on the tone already set for us by Dami Lola, I'll go into this. I'll be skipping most of my slides because I believe Dami Lola has really dealt with those parts very well. But this very important quote by Suze Oman is what I want us to look at. Estate planning is an important and everlasting gift you can give your family. And setting up a smooth inheritance isn't as hard as you might think. It isn't as hard as you might think. And as Dami Lola has said, a call to Meristem will show you that it's really not as hard as you think it is. So I will skip most of this. I will skip because Dami Lola has given us so much about it, estate planning, what it means. Control and utilization of assets is one reason why I should be able to, why I should plan my estate, because control and utilization, I'm able to wield it. I'm able to control how my assets are dealt with. And of course, utilization, even in my lifetime. So estate planning is not only for when we are dead, it's actually a tool that can even be used in our lifetime. And that is all we shall be seeing. And then some of the tools like Dami Lola has already told us: trust creation, deed, life insurance, property ownership. These are tools we are going to be going in depth to discuss this morning. And then another quote, I like quotes really. That is not the end. There remains the litigation over the estate, by Ambrose Bierce. That is not the end. There remains the litigation over the estate. So if you don't heed what you will learn from today's webinar, of course, you're sure that the second part of that quote would apply. There remains a litigation over the estate. And you may be thinking, I don't have so much. I don't have billions like the families that Omoife mentioned. But really, you don't have to have billions to have litigation. I've seen litigation over less than 10 million naira. I've seen litigation over less than 5 million, even over less than 1 million. So it is important we plan our estate. So I will go quickly to the first tool, which is trust. Basically, we have two types of trust: the living trust and the testamentary trust. The living trust is a trust you create in your lifetime, and it starts operating even while we are alive. And remember, we are looking at all these tools in the context of the unique circumstance of the family. So as we discuss the different tools and the different devices we can use for estate planning, let us remember that what will work for one family may not work for another family. There are unique circumstances that apply to each family, and those are the things that an expert will be able to advise you on. So just bear that in mind as we look at trust. Trust, a living trust. If I have a child and I'm already old, right, and I had my children late in my time, a living trust may work for you better because we don't have control of our lives as we have heard already. We don't have control of when we are going to die, when we are going to go. So it's important we have all of this in perspective. So a living trust is a trust that takes effect even while the testator is still alive. A testamentary trust, as he said already, it speaks from death. It's after the person has died that the trust begins to speak. Some of the pros and cons of trust. Once you create a trust, you are able to avoid probate, and of course it minimizes the tax you pay if you are able to perfect your trust in your lifetime. And of course the settlor will, however, have to have the fund for the initial startup. You have to fund the trust because of course there are funds, the trust companies don't do it for free. You have to make payment for the initial startup of the trust. So that, of course, that expense has to be borne by the settlor. And then, of course, the cost of transfer of the asset to the trust. We always advise that the asset to the trust should be transferred immediately so that you don't wait and start incurring that expense at the debt. Of course, it gets more difficult. So the cost of the transfer of the asset will have to be borne. And then loss of some flexibility and unrestricted control over one's asset. Of course, once you transfer it to the trust, you will lose some control over the assets. Maybe you are the one that has been collecting the rent. Once you transfer it to the trust, you may have to have the trust collect the rent and maybe remit to you based on your instruction because as contained in the trust instrument. And of course, there might be situations of misappropriation of trust. That is why it is important for you to choose your trustee. You know, we have partnered so much with Meristem, their trustee company. So it is important that in deciding the trust to use and the trustees to use, it's important you take cognizance of the pedigree of the trust company you're using. Then before I leave trust, I want to mention foreign trust because I see a lot of us prefer to use foreign trust. Of course, there are some good things to be said about foreign trust, but it is important that you don't just choose a foreign destination and say, okay, I want my trust to be there. It is important for us to check the jurisdiction because what applies in one jurisdiction is different from another jurisdiction. Some jurisdictions are very good for trust. So you need to get advice on the jurisdiction that are favorable. And of course, when you're looking at that, you look at issues of jurisdiction that recognize foreign judgment, recognition of self-settled trust, local taxation. Those are the things you may need to look at before you decide on which company or on which jurisdiction to establish your foreign trust. And of course, you have to look at the stable political environment. You don't want to go to an environment that is not very friendly and that has too much upheaval. So those are the things and advice you may need and to consider before you decide on a jurisdiction to create your trust. And then we go quickly to the deed of gift. Of course, deed of gift is a gift you give in your lifetime. It is inter vivos disposition of property. Give it to this particular person or this particular child, and you actually perfect the giving of the gift. You actually give the gift to the person. You actually donate that gift in your lifetime. And of course, it must be by deed. And of course, there must be intention to make a gift. There must be intention to make a gift, either voluntarily given, and it must be voluntarily given. It mustn't be that you are under undue influence and no consideration must be given for a gift. And like I said before, transfer must be absolute. And then, of course, some of the advantages that, of course, ambiguity is clarified immediately. In your lifetime, every child knows what they are going to get, and indeed that settles it. And then unwholesome practices like will forgery, there have been issues that people have forged, and of course, there is no capital gains tax because you did not sell the property. And of course, you avoid probate when you use deed of gift. And then we move quickly to wills. My time is fast spent. Why should I make a will? Of course, you can give, it gives you the opportunity to give a clear direction of what you want to be done. Okay, clear direction, not just of how your asset is going to be dealt with, or okay, even how your body, oh, I want to be buried in so-so place, I want to, all those things can be taken in your will. Of course, your administration of your estate runs smoothly because there are people there who would know what they are supposed to do. The executors will go on and do their work immediately. And of course, you prevent uncertainty over who gets what. You appoint guardians for your children, for minors, and it is easier to process an application for grant of probate. It is easier, a little bit easier than letters of administration where there is no will. Of course, it becomes a little bit more cumbersome. And then, of course, how a will can be revoked. It can be by another will. It can be by destruction. You destroy it. And then, of course, it can be revoked by a subsequent marriage, which is not a customary marriage. Attorney is a formal instrument by which one person empowers another to act for him. So it's just an agreement, a power of attorney that you draw up, empowering another person. Okay, take care of this asset, take charge of this asset, and of course, deal with it in the way you want to deal with. Or take this car and use it, take it to mechanic, use it to do Uber, use it to do whatever you want to do. So exactly what you want to do, you put it inside the power of attorney, and the person that donates the power is called the donor, and of course the attorney, who the person that now acts. So I can take a property and give to and do a power of attorney and give it to a particular child. So that person takes charge and is in charge of that asset. Of course, people also use life insurance. A person may take up a life insurance to protect and provide for a particular beneficiary. So a power of attorney is the life insurance. The only if the person that takes out the life insurance did not pay their premium, of course, it becomes difficult for the beneficiary to take advantage of. It becomes difficult for the beneficiaries to take advantage of the premium from the life insurance. So it's important that all this, doing your life insurance, you can nominate a secondary beneficiary, because you can have your wife or your children as your beneficiary of your life insurance. But we have seen cases where families die in an accident. So in your insurance document, you can provide for who takes charge when the beneficiary also dies with the person that took out the insurance. And then property ownership. Property ownership. You can buy properties in the name of the person you want to give it to. So from the onset, you make up your mind, okay, this asset is what I want to do, and this asset I'm buying, this house I'm buying, this car I'm buying it in the name of my wife, I'm buying it in the name of this particular person. And of course, when you're buying property, remember it is joint ownership of property that guarantees right of survivorship. So if I buy property in my name and my wife's name, and it's joint ownership, once the man dies, once one spouse dies, or the woman dies, the other party takes up the property immediately. So there is no need to go and get a probate and of survivorship. Where there is tenancy in common, it's all in the drafting of the documents. Also, properties can also be acquired, I've already said that, in the name of the children. And then properties can also be bought in corporate name. You can buy property in the name of a company. And of course, the position in the newcomer now has it, when it comes into force, the newcomer now has it that you can have one shareholder. So when you have one shareholder, you can go right ahead and own the property, own the company by yourself, so that when you die in the will, you can transfer the shares in that company to whoever you want it transferred to. So that is a very good way of owning property. And the newcomer has made it better, because now you don't have to have two shareholders to own the company and be shareholders in the company. One shareholder can hold the shares of that company so that at death, you can now decide, okay, I want 50% of that property that I bought in the name of that company to go to this child. I want 20% to this child. You can now divide the shares in that order. And I'll end with this. I have 1 minute more. It must be stated that whatever the device adopted, there are equally drawbacks. It should be that estate device meets the goal of the estate holder. So you see that, like Dami Lola has told us, it's not something you can just decide, okay, let me go and do this by myself. You must have professional advise you on how to go about it and tell them your intentions, and they will advise you on the best way forward. I had a client recently that was asking me, okay, I want to create a trust, I want to do this. I said, please tell me, what do you want to achieve? And by the time he told me what he wanted to achieve, I said, you don't need a trust. This is what you need to do. And he was so happy, even though I did not earn that money, but at least I have a satisfied client who I know will bring more business. And I will end with this remark. It is well worth the fee, because you save so much in estate planning if you do it right. If you do it right, it is attributed to our Remark. If you do it right, please carry that in your mind. If you do it right, it is well worth the fee you will pay, and you can't compare the benefits when it's right. Failure to plan eventually destroys whatever empire which you may have acquired. Thank you all so much. Thank you.
Thank you, Ebele. Thank you. Thank you so much. That was indeed very insightful, very enlightening and informative there. I guess we all learned a lot from that. Living trust, foreign trust, deed of gift, power of attorney, life insurance, property ownership. All of these are essential tools that we can use in preserving our wealth, our legacies, and transferring them across generations. Ebele, thank you so much. She's a partner with Pinuka Attorneys and Solicitors. We want to say thank you. We're grateful for this. It's not over yet. A couple of questions have been coming in. At the end of the session, once we have the third speaker finishes, we'll take all of your questions. So please don't stop dropping them. I can assure you that they will be answered carefully. Next in line is Mr. Moshood Shehu. Moshood Shehu, he is a legal counsel with extensive experience in commercial and transactional practice. And he's going to be taking us on the legal landmines to avoid in planning your estate as a family business and as an entrepreneur. Just before he gets started, I remember the story of a friend, very close friend. We were much younger at those days. He had a father who had 3 brothers. They were into some form of partnership, joint business, and one of the fathers died, and one of the brothers died, exactly. I think it was the elder brother who passed on. And immediately he passed on, it was as if the business went into comatose. His wife took the other brothers to court. Businesses, transactions they usually would get wasn't coming. So the question was, what did they do wrongly as partners in that business? You know, could they have done something different that even at the demise of one of them, the business could have continued successfully? The families, the wives, the children would have nothing to lose. So this morning, Mr. Moshood will be taking us on the legal landmines. Are you an entrepreneur? Are you into business? Are you into partnership? What can you do to ensure that your assets, your legacy, your wealth at your demise can be transferred to your children and other beneficiaries? Mr. Moshood, you have the floor. Thank you.
The outline of my presentation will be an overview of estate planning, mechanism of estate planning. I'm not going to reinvent the wheel. Ebele has done justice to that already. But I'm going to talk about the landmines when you are using any of these tools, and then suggestions before concluding. Briefly, estate planning involves conscious efforts, acts, and processes aimed at managing and disposing a person's assets to achieve certain objectives. It is a multidisciplinary topic straddling finance, law, and taxation. Even in law, you have to be adept at commercial law, property law, family law, private international law, because situation may arise where you have assets in other jurisdictions, you are married to somebody from another country, and you have bank accounts in some other jurisdiction. So a knowledge of private international law will be very relevant. So That's why I said estate planning is organic, is eclectic. You need to know so many things, and you need to be very conversant with current laws and legislation. So even if you have an estate plan now, you may need to revise regularly. Like there's the new Finance Act now. You also have a new amendment to the Company and Allied Matters Act. So you may need to look at your plan and see whether this plan is conversant and is compliant with the new amendments to the law. So I'll quickly have a look at some of the mechanisms I've jotted down. Ebele has done justice to will, trust. I'm going to speak on marriage. People may be surprised why marriage is an estate plan, but it is. And then life insurance, Ebele has done that. Gift in survivors, Ebele has done that. I'm going to look at some of the landmines in some of these mechanisms and how an entrepreneur, a family business can take lessons from these landmines. And I'm also going to provide suggestions and way forward how families can preserve. You need to grow the wealth, preserve the wealth, and then distribute the wealth, and in a sustainable way, so that generations coming after then will have the benefit of the hard labor of their patriarch. First, let's look at wills. Whether if you're a family business, you're either a sole trader, you're into a partnership with somebody, or you have a company. So in any of these, you are a man. I mean, a company is not going to make a will. You are going to make a will yourself. So what are the landmines that are inherent in making a will? People think they have unrestricted testamentary freedom. They can make any will anyhow they want. I'm sorry to disappoint, that is not the case. There are 3 restrictions that I've penned down. The first one is that I'm sorry, I practice in Lagos, so I'm going to use Lagos state law as my reference point. Under the WIS law of Lagos State, for example, you need to make reasonable financial provision for your dependents, that's your spouse and your children. So even if in your heart of hearts, you do not want to do anything for that spouse because the spouse has not taken care of you or has not been responsible, but you are not formally divorced, and the dependents have abandoned you, they've gone abroad, they've not done anything to aid your life and your living in your old age, under Section 2 of WIS law of Lagos State, after 6 months of grant of probate, they can apply to court and say, my dad did not make enough, or my mom, as the case may be, did not make enough provision for me in his will. And the court can, in its discretion, look at the circumstances and then make provisions for them. And the provision will be made in accordance to their standing in life. So if the man is already used to riding Lamborghini, you can't say give him 10,000 naira a month. They have to make that. The key word is reasonable financial provision to dependents. So that's a clause on your testamentary freedom. You cannot, I'm sorry to say, cut off your dependents from your will. Then the second restriction is the customary law restriction. We may be surprised that even the WIS law has recognized customary law. And you can only make your will if you have freedom in respect of everything. But for properties subject to customary law, you cannot make a will to be contrary to the tenets of the customary law. I will give the example of the popular case, Lawal Usula and Lawal Usula. The man is a Benin chief, and he made a will. And I will read out an exact quote from that will. He said, I declare that I make the above device and bequest when I'm quite sane and well. It is my will that nobody shall modify or vary this will. It is my will that the native law and custom of Benin shall not apply to alter or modify this will. The Supreme Court said no. Supreme Court said no. The Diogbe, which is the house you are living, must go to your eldest son. You cannot, by will, give this to someone else. So that is an impairment on your on the testamentary freedom of the testator. The last restriction I will briefly mention is Islamic law restriction. Under the West Law of Kaduna State, for example, Section 2, a Muslim cannot will out the whole of his estate. You cannot. In fact, I'm reliably informed that as a Muslim, you probably can only will about 1/3 if you want the Muslim law to apply to the description of your estate. You can only will out 1/3 of your estate, for example. So these are some of the landmines that when you are making an estate plan, you need to be aware of. Another one is the trust. Trust, yeah, is a very common one and people is catching on now. But one unique thing about trust is that the title to the property will reside in the trustee. It's only that the trustee must use and manage the property for the benefit of the beneficiaries. So we give the title to Meristem, for example, but the proceeds from the estate goes to the beneficiaries. So what if the person, the settlor, the person making the trust has already acquired property in his personal name? Then he will have to transfer to the trustee, and then of course you consider the transfer cost, governor's consent and all of that. So if you want to make a trust, I'm directing this particularly to younger, some of our younger guests, maybe you should start trying to make them in the name of the company straight away. Secondly, some people have concerns about the trustee misconduct. What if I have a trustee? Yes, the current management is okay now. What of maybe a new management comes and they are misbehaving? I have good news for you. Trustee companies are regulated by the Security and Exchange Commission. So, of course, the regulator checks them here and there, and then they also have to submit fidelity bond to the regulator. And then again, in your trust, you can also appoint a protector. Maybe your trusted uncle, a trusted friend, or your spouse, to have an overview and a superintendence over the trustee. It's allowed, and of course you can go to court. And then you may also have the concern, what if the trustee goes into liquidation? The smart thing to do actually is to have successor trustees embedded in the trust deed. God forbid if this trustee goes into liquidation, the next one, you can mention them by name. In fact, a trust deed is settled. We said a trustee to be appointed by the president of the Nigerian Bar Association at the time any liquidation. So of course, so we are sure that even if one trustee goes into liquidation, another one will take over. And of course, we have the bankruptcy protection. If the trustee goes into liquidation, his assets are not to be taken over by creditors, but for the settlement of its people that have things with it. Then the next one is marriage. I will want to, Ebele has not touched this. I want to say that marriage is actually a default estate plan. People may be wondering, how is marriage? Because you go to marriage without even knowing some of the implications. If you marry under the Marriage Act, for example, and you die without a will, the default provision is section 46(1) of the Administration of Lagos State, if you're in Lagos State. And that gives all your personal chattels to your spouse. All your cars, video, everything in your house, or personal chattels, things you can refer to as personal chattels, goes to your wife. And of course, the real estate, if you die without an issue, everything goes to the wife. If you have issue, 2/3 to the issues, and then 1/3 to the spouse. The problem with this is that the extended family has not been recognized. And we know in Africa, we are embedded in our communal system. So, and this particular provision, in my opinion, is engenders continuous strife, litigations, and why people have not taken advantage of this. So that's also another landmine that you may need to, so if you don't want this to apply, of course, we can exclude it by a will, and then you can also exclude it by some other estate plans. Another thing, Ebele has mentioned this, but I quickly need to maybe point out some of the landmines there. If you have something, joint tenancy with the right of survivorship, you need to properly describe yourself. Don't go and buy a property in the name of Mr. and Mrs. Brian Oliide, because Mrs. Oliide may change. The current Mrs. Oliide may not be the next Mrs. Oliide. So let it be Mr. Brian and Mrs. Bridget Oliide. In fact, some people will put date of birth. So if there is a coincidence that the next Mrs. Oliide is also known as Bridget, at least their date of birth will not be the same. Then, of course, another issue there is if there is a divorce or a remarriage. So you have a joint property, Mr. Brian and Mrs. Bridget Oliide, but then there is a divorce. How do you look at that? So this is another landmine. And then again, we go to the next one, which is gift. Yes, gift is a veritable means of distributing your estate, and it's being used, it's being widely used. And one good thing about it is that even if you want to transfer it, of course, governor's consent is needed in Lagos State, but I think they will give you a concession because there is no consideration on it. But the problem with gift is that delivery has to be in the presence of witnesses. And you may actually want to do it coded. You don't want people to know that I've given my flat in Dolphin Estates to my brother or to my sister or to my son. But delivery has to be in the, for a gift to be valid, it has to be in the midst of witnesses or in the presence of witnesses. And of course, there has to be immediate possession. You may not want the donee to have immediate possession, but then the crucible of the law is that the donee must have immediate possession of that gift. So I believe this is another drawback for this particular tool. And then I'll go to the family investment company, which will dovetail into family business. I actually put this one last so that I can then talk about family business. The family investment company works in this way. I have been acquiring assets in the name of Moshood Shehu Limited, for example, 2 flats, 3 flats here and there. Then I put my spouse as a shareholder. Then all my children are also listed as shareholders in proportion to which I want to give them. Now the issue is the company is also trading, and how do I preserve the assets? Or the company is blossoming. How do I preserve the assets onto the next generation? According to a survey made by PwC, the accounting firm, in 2018, 77% of family businesses in Nigeria plan to pass on management to the next generation, but only 10% has a robust documented succession plan. So this is a drawback for the family company because yes, the patriarch has worked, he has acquired, he has amassed all this. How does it pass on to the children, the grandchildren, the great-grandchildren? This is actually a particular headache. I'm going to profile suggestions and solutions in the next slides, but for now, we should know. Then another thing is you impair the assets. Another issue is that you may impair the assets. You have acquired everything in the name of the family company, and then now there is a court judgment. And then the creditor has to go against assets that you have set aside, you have preserved for your children. How do you want to do that? I also profile solutions on how you can navigate some of these issues. Then, of course, the family businesses now, which is an offshoot of the family investment company that I've done. What are my planning suggestions for family businesses? You can have a business, like I said, as a sole trader, as a sole owner, incorporating a company and in partnership. And like Ebele said, you don't even need a second partner now to register a company. You can do it alone as a sole owner and as a sole director. So my suggestion for family businesses when you are doing your estate plan is that try to separate your assets holding company from your trading company so that you don't impair your assets. You don't put your assets, those things that you have labored for and you have gathered and preserved for your children, you don't put them at risk. So if you are buying assets in the name of your company, for example, a flat in Dolphin, a flat in Parkview, a flat abroad, and all that, don't do it with the company you are hustling with. I mean, to use the word, just put it somewhere. Don't do transaction with it. Don't impair it. Then incorporate another company and then do also with that one. If any creditor comes, it's only that one they will come after. Then have a clear succession plan. Succession plan that says who takes what. Then also recognize the divergence, dichotomy between ownership and management. A member of the family, of course, naturally, you may want to give him shares in the family business, but he may not be interested in management. So don't force him. The young man may not even be around, or the young lady may not even be in Nigeria. So don't force them to be involved in family management. Just recognize that that dichotomy in the succession plan you are making, that they may be interested and they may not be interested in management. But the ownership is their birthright. So look at that. Then communicate that succession plan. Communicate it. Let it be clear. Let it be focused. Let it be robust. Of course, the succession plan will be, you need the help of professionals to help you put it together. And then the family business can then survive you and go on from generation to generation. But a key thing is all these plans, how do you make them enforceable? You can have a plan, thick as the Bible, and then after you are gone, somebody says, I'm not going to abide by this. What do you do? So my advice to clients will be that do a shareholder agreement if they are shareholders. Make a shareholders agreement. Shareholders agreements are binding in Nigerian law. In fact, I will go further and incorporate it into the articles of association of the company that is registered with the CAC, so that it is incorporated by reference, so that that thing is binding on them, the clear succession plan. Then, of course, the trend now is actually to have a family charter, because then you have a large family, and some, not all of them are shareholders, some are grandchildren, some are great-grandchildren. Have a family charter. It's like the family governance constitution. It will define who is a member of the family, the next generation, the next generation, who wants to work. If he works, how much will be the remuneration, the dividend policy, because you have to have a fair dividend policy. The ones managing may not be in need of money, but the ones who are not involved in management, they may be harassing the ones working, say, give us money. So if you have a fair dividend policy that maybe dividends should be distributed twice a year or quarterly, of course, everybody will have what is due to them. So that should be there. And then the family charter should also have dispute resolution. If there is a problem, how do we resolve it? You don't want to wash the family, the dirty lining of the family in the public. So maybe you may look at mediation and some other dispute resolution mechanism. So of course, the family charter is also going to look at funding, because if you are thinking of next generation, what the patriarch has done may not be enough to carry you to the next level. So you may want to look at PE funding, private equity funding, and some of these things. So the family charter is actually a comprehensive document that will address governance, that will also address so many other things that is related to the family business. And then you look at maybe appointment of independent directors. So maybe this would look at, this will help bring in integrity and robustness to management of the company. And what I advise people to do is that this family charter, not all members of the family will be shareholders in the family business, but for whatever is worth, make it an addendum to the shareholders agreement. So at least those who are shareholders will be bound by it, so that you look at mechanism by which you can strengthen and give legal force, legal authority to some of these things. Because if we do all these beautiful documents, nicely bounded, and we just put it somewhere, somebody will just go to court and just one argument, and then everything is scattered. So of course, law is also organic, is growing. We are thinking of how to make some of these things binding. But for now, I would advise, when you have done this family charter, make it as an addendum or an appendix to the shareholders agreement. And of course, the ultra wealthy may consider having a family office, which is a dedicated structure of professionals, structure that will manage, that will look at all these things we are even talking about. Because if we are talking of someone that has a $1 billion, I don't think the person may even be talking. I mean, you may want to have an in-house family office that will discuss everything about governance, that will discuss everything about funding, all these things that we have talked about. So, of course, there are businesses like Meristem that also perform the functions of the family office. So, for those of us who are not this ultra wealthy, Meristem may very well be our family office. Then, the last advice, my last thought on this is top it up with a will. If this is the only thing you will take away from this presentation, please take this, top it up with a will. What I mean by this is, after you've done all this, you've done gift, you've done deed of gift, you've done this, put down a statement in a will. This is what I've done. Because the will has the force of law once probate is given. And unless you can prove that the testator was insane or infirm at the time of making the will. So if you've done a gift, so that people don't go around looking for that house, Baba has one house in the Anopaja, say it in a will that my house in so place, I've given it to my son. So say, you are not going to pay probate fees on that, but it is your instruction so that people don't, people will respect it. And of course, by the time probate is given and all those court stamps are put here and there, then you have given some kind of bigger force and imprimatur to what you have done, like Meristem vowed to be fine. Conclusion, estate plan, you can creatively combine several estate planning tools with the help of professionals like Meristem. Thank you. I'm ready, and thank you for listening.
Thank you so much, Barrister Moshood. That was very enlightening. A lot of insights and information passed across there. You know, I never knew there were customary provisions and Islamic provisions that would even impact your will. Thank you so much. There are a lot of questions to be asked here on the question chats, and I'm going to read them out and ascribe them to our panelists for our responses. Please, panelists, as much as possible, let's just answer quickly. We have about less than 10 minutes more for this. Now, the first question says, good morning. I heard you mentioning wills in relation to preserving and transferring wealth. What is the role of insurance in this against physical material damages and infirmities to wealth owners? This goes to, I like to give this question to Mrs. Eneda.
Thank you, Moefe.
Yes.
Will is different from an insurance. Insurance, you take out an insurance policy, and of course, inside insurance policy, you declare who your beneficiaries are. And once you die, the insurance is paid to the beneficiaries mentioned in the insurance policy, which you have with the insurance company. But a will is a document, is a testamentary document which starts to speak from, of course, you have to get a probate. You don't have to get a probate to get advantage of the insurance policy, take advantage of the insurance policy. But for a will, you have to go to the probate registry at the High Court of the state where the deceased was resident. And of course, that is where you're going to get a probate before you take advantage of anything mentioned in the will.
Okay.
That is a major difference.
Thank you. Thank you so much for that. Barrister Moshood, this is for you. The question says, in a situation where a testator in his last days of death was a Muslim, but he, however, wanted a will stating that he does not want his estate to be distributed in accordance with the Sharia law. What is the position of the law regarding such?
If it will also depend on the residence of the testator. But if the testator has specifically excluded Sharia law, that question is mute. I can't say how it will go. I've given you the example of Lawal Usula and Lawal Usula. So I believe, generally, this is my opinion now. If Lawal Usula and Lawal Usula relates to a specific property that cannot be devised customarily to someone else apart from the eldest son. So that is clear for the fact. But if the person has specifically excluded Sharia in his will, I believe the will stand. And then the property of the testator will be distributed according to his will and not in accordance with Sharia law.
Okay. Dami Lola, this is for you. It says, at what age is it considered right or appropriate for a person to write a will?
Okay, so the moment you're an adult, 18 and above, and you have assets in your name, so for a young individual who is working and has a retirement savings account, you should actually have a will, you know, to take care of how you want that to be sorted in the case of any eventuality that we all do not envisage. So when you begin to acquire assets, you need to have a will. That's just basically it. So, and I like the fact that Barrister Moshood said, top it up with a will. So even if all you have is a will to start with, to take care of the basics, you know, just start with that and ensure that you at least have identified certain things that you've passed on in a will.
Great, thank you, thank you. Ebele, this is a question for you. It says, what if a trust is created in the favor of a wife and children? Then unfortunately, the whole family dies in a car accident. What is the fate of the trust created?
Thank you very much. In trust documents, in trust deed, provisions are usually made for that, and it actually states what will happen where the gifts or the trust fails, what should happen to it. So a well-drafted trust takes care of what happens to such situation. So you can make a trust saying, okay, this child should be trained to university, school fees shall be paid and all that. And of course, the child dies and you are no longer there. There's usually a provision in the trust deed, the trust instrument, which actually states what would happen in such a situation. So you should be taken care of when you're drafting the trust deed. It's the same thing that happens.
Mr. Village, a follow-up question.
Yes. Okay.
A follow-up question. What's the clear distinction between a will and a trust? What's the clear distinction?
Okay, I think we referred to, okay, what a will is that a will, like we said when I was differentiating a will from an insurance, is a testamentary document which speaks from death, and it is probatable. You have to go to the probate registry to get a probate before the will begins to speak, before you take advantage of anything or any device or bequeath you made in the will. But in a trust, you does not have to pass through probate, because you have transferred the asset to the trust and you have done all that should be done for the trustees to take advantage and implement the trust instruction. There is no need for it to go through a probate. Yes.
Okay, thank you. Thank you. And now this question is for you, Dami Lola. It says, how long does it take to get a letter of administration? And do someone need a letter of administration when there's an existing power of attorney on a property?
Okay, Omoefe, that question is for you, being the team leader of our probate department. So I would allow you to answer that question.
Yes, okay. For us at Meristem, how long does it take to get a letter of administration? On the average, we assure you within 4 to 6 months, bearing all bottlenecks with regards to the client having to provide relevant information and documents, and also bearing all bureaucracies at the probate registry. But however, traditionally, it is said it takes an average of 18 to 24 months to get a letter of administration. But for us at Meristem, we pride ourselves within 6 months, you can get it. Then it says, can a letter of administration, when there's an existing power of attorney on a property, you would still require a letter of administration if that property needs to be sold. If that property needs to be sold at any point in the future, yes, a power of administration definitely will be required. A power of attorney only gives you the right to act, but a letter of administration gives you the legal right to administer that property. One more question, and I think I'd like to give this to Mr. Barrister Moshood. It says, can a family office take care of distributions to family members periodically and also pay dividends yearly? Or is it only dividends that should be paid from the office?
A family office can actually do everything.
Okay.
It depends on the instruction of the person, the patriarch. If you have philanthropic and charitable activities, then you can give it to the family office, and they do everything. They take care of everything. So yes, it comes within the remit of what a family office does.
All right. Thank you. Thank you so much, panelists. Thank you, our invited guest. I want to believe it has been an enlightening session thus far. For me, it's been very much enlightening and informative, very much educative, a lot of things which I never knew. We cannot exhaust all of this. It's a wide topic. That is why we've termed it our Wealth Preservation Series. I'd like you to be in the lookout and in the watch out for the next edition, which would come up shortly, and we'll get to notify you as soon as we're ready for that. We're coming to the conclusive stage of this, and as we all know, every ship has a...
Okay,
Yes?
sorry, let me interrupt you. So
Okay.
I know that there are still questions that we haven't answered. Can we encourage participants to send us an email? Because for some of them, we don't know who they are. Their names are not showing. So we can't even pick those questions to send them private messages after the meeting. So they can send us an email, trustees@meristemng.com, so that we can answer their questions. There are quite a number, but we have to keep to time.
Yes, very true. Okay, thank you, Dami Lola, for that. So for those who still have questions, trustees@meristemng is the email for you to forward your questions. At this point, I'd like to call on the Deputy Group Managing Director of Meristem Securities Limited in the person of Suleiman Adedokun to give us the closing remark to this session. Suleiman, please, can we have you?
Okay, thank you very much, Omefe. I would like to appreciate the panelists and everybody on this webinar. It has been an exciting topic and discussion always. And the topic of estate planning is a topic that everybody needs to just take seriously. And the reason is that, thank you very much. And so when you also live in the world, I mean, you need to also plan on how to live on boarding. People always say, I mean, the best is to die light. And the discussion of today is actually about this. The entire world is becoming more complicated.
Yeah.
I guess it's network issues.
Must be the network. I guess we will just have to pray for a speedy 5G introduction in this part of the world so that we can, these hiccups can stop. But let me just round up. I believe what Suleiman was just trying to say is the need for us to take decisions and to take it promptly, because we're all advised to die light. You know, we don't know the time, but we should try to put our house in order. And like I mentioned earlier, we need to remember that it is only a myth. There's no connection, no relationship whatsoever with you planning your estate, writing a will, setting up a trust, and your demise. There is absolutely no correlation. Putting your house in order gives you the advantage of being proactive about how you want your estate to be distributed, rather than leave it to other people's judgment. So I leave you with this parting word, ladies and gentlemen. It's your legacy. So please do all you can to preserve that legacy. We look forward to receiving questions from you. We are very much available to handhold you. We work with partners. You've seen some of our partners here today. To handhold you to make sure that this process is a seamless one. And we can only just wish you the best in your endeavors. Enjoy the rest of your day, everyone. Thank you for coming.
You've reached the stars. Now let's see you conquer galaxies.